Breaking news. Minutes ago, the Supreme Court issued an order that is already reshaping the Second Amendment landscape nationwide. And if you're just hearing about this now, you need to understand immediately what just happened and why it matters. This is not a case that's been working through the courts for months with scheduled oral arguments and predictable timelines. This is not a routine procedural order that legal experts expected. This is extraordinary Supreme Court action that moved with stunning speed, catching state governments, lower courts, and even legal scholars completely off guard. The order dropped without warning, without the usual signals that major Supreme Court action was imminent, and it carries immediate legal force that is already triggering responses across the entire country. This is not routine court action. When the Supreme Court issues emergency orders, expedited decisions, or sua sponte interventions that bypass the normal deliberative process, it's because the justices believe the constitutional stakes are too high to wait, that rights are being violated right now, or that legal chaos has reached a point where immediate clarification is necessary. Gun owners in every state will feel the impact of this order because it doesn't just affect one jurisdiction or resolve one narrow legal question. This is a Supreme Court intervention that establishes principles, sets standards, and sends signals that every lower court, every state legislature, every law enforcement agency, and every gun owner in America must now reckon with. The legal ground just shifted beneath everyone's feet, and the consequences are already beginning to unfold in real time. So, what did the Supreme Court just do? And why does this order carry such enormous weight? The order is immediate and legally binding, which means it takes effect the moment it's issued, not after some future implementation period or grace period for compliance. When the Supreme Court issues an order in a case, whether it's granting emergency relief, staying a lower court decision, or clarifying how a previous ruling applies, that order has the force of law immediately. This is active law, not commentary or guidance or suggestions about what courts should consider. This is the Supreme Court exercising its constitutional authority to interpret the Second Amendment and to ensure that constitutional rights are protected uniformly across the nation. Emergency or expedited orders carry national authority, even when they're issued in response to a case from a specific state or circuit. The Supreme Court's interpretation of the Constitution applies everywhere, which means that principles established in this order bind courts and governments in all 50 states, regardless of whether those states were parties to the underlying case. Lower courts and states must now respond to this order by adjusting their practices, revising their laws, halting enforcement actions that conflict with the Supreme Court's interpretation, and ensuring that their conduct aligns with what the nation's highest court has just said the Constitution requires. The failure to respond appropriately and promptly creates legal exposure for state officials, opens the door to civil rights lawsuits from gun owners whose rights were violated, and invites further Supreme Court intervention if compliance is not forthcoming. Now let's talk about why this order fundamentally changes how the Second Amendment is understood and enforced across the United States. The order shifts interpretation or enforcement of Second Amendment rights in ways that expand constitutional protection and narrow the scope of permissible government regulation. The Supreme Court has clarified standards, rejected interpretations that lower courts or states had been using to justify restrictions, and established that certain types of gun regulations cannot survive constitutional scrutiny under the framework the court has established. The order places limits on state discretion, making clear that states do not have unlimited authority to regulate firearms however they see fit based on contemporary policy preferences or local political judgments. Instead, gun regulations must be rooted in historical tradition, must respect the core right to keep and bear arms, and must not impose burdens that effectively deny constitutional rights to law-abiding citizens. The Supreme Court is emphasizing historical tradition and constitutional grounding as the only legitimate basis for gun regulations. Modern concerns about public safety, policy arguments about reducing gun violence, and statistical claims about the benefits of restrictive laws do not justify regulations that lack foundation in the historical tradition of American firearm regulation. This represents the court reinforcing the Second Amendment's national scope and ensuring that constitutional rights don't vary dramatically from state to state based on political preferences. A constitutional right means the same thing in California as it does in Texas, in New York, as it does in Montana. And the Supreme Court is using its authority to ensure that uniform constitutional standards are applied everywhere. This Supreme Court order is creating enormous pressure on states that have built extensive gun control frameworks. And the pressure is forcing rapid legal and political recalibration. Some states must now pause enforcement of laws that conflict with the Supreme Court's order, revise statutes that the order has effectively invalidated, or completely rethink their approach to gun regulation in light of the constitutional standards the court has clarified. The tension between state power and federal constitutional authority is at the heart of this conflict. States have traditionally exercised broad police powers to regulate health, safety, and welfare within their borders, but those powers have limits when they collide with constitutional rights. The Supreme Court is making clear that Second Amendment rights impose real constraints on state regulatory authority, and states that have been pushing those boundaries are now being forced to pull back. Defiant states are now legally exposed because continuing to enforce laws that conflict with Supreme Court interpretations of the Constitution creates liability for civil rights violations. Gun owners can sue seeking damages, attorney's fees, and injunctive relief. And those lawsuits are far more likely to succeed when they can point to clear Supreme Court guidance that the state is ignoring. This is the beginning of major legal recalibration across state governments, law enforcement agencies, regulatory bodies, and court systems. Officials are holding emergency meetings to figure out what this order means for their operations. Attorneys general are reviewing enforcement practices to identify areas of vulnerability, and state legislatures are preparing to either rewrite gun laws to comply with the Supreme Court's constitutional standards or to dig in and fight, knowing that resistance will be costly and ultimately futile. The ripple effect of this Supreme Court order is already spreading through courts and government agencies at every level of the system. Lower courts will cite this order immediately in pending cases involving Second Amendment challenges. Judges who were uncertain about how to rule on gun regulations now have fresh Supreme Court guidance that clarifies standards and provides a framework for analysis. Defense attorneys in criminal cases involving firearms are filing motions arguing that their clients' prosecutions are based on laws that the Supreme Court has effectively invalidated. Plaintiffs in civil rights cases are using the order to strengthen their claims that state gun regulations violate constitutional rights. Agency confusion and rapid legal adjustments are happening behind the scenes right now, as regulatory bodies try to understand what the Supreme Court order means for their authority and their operations. The ATF at the federal level and state-level law enforcement agencies are reviewing policies, pausing certain enforcement actions, and seeking legal guidance about how to proceed. Emergency motions and case reviews are already underway in courtrooms across the country. Defendants are asking judges to reconsider convictions, dismiss pending charges, or grant relief from sentences imposed under laws that may no longer be constitutionally enforceable. States and advocacy groups are filing competing motions arguing about what the Supreme Court's order actually means and how broadly it should be applied. This is the start of a chain reaction that will play out over weeks, months, and potentially years as the legal system absorbs the implications of what the Supreme Court just did and adjusts to the new constitutional reality the order has created. So, what does all of this mean for gun owners right now in the immediate aftermath of this Supreme Court order? The first thing to understand is that awareness, not panic, should be the response. This order likely strengthens Second Amendment protections, clarifies constitutional standards, and creates better legal footing for lawful gun ownership. But it doesn't mean that all gun regulations have disappeared or that there are suddenly no rules governing firearms. Assumptions based on old interpretations may no longer apply, which means gun owners need to understand that legal landscape has shifted. What was considered settled law about permit requirements, carry restrictions, purchase procedures, or other regulations may now be open to challenge or may have been effectively invalidated by the Supreme Court's order. Gun owners should pay attention to how their states respond to this order. Some states will comply quickly, adjusting their laws and enforcement practices to align with the Supreme Court's constitutional interpretation. Other states will resist, either through litigation designed to narrow the order's impact or through continued enforcement of laws that may now be constitutionally questionable. Understanding what's happening in your specific jurisdiction is important because it affects your rights and your legal risks. The emphasis should be on lawful, informed exercise of rights. The Supreme Court is protecting constitutional rights, but those rights exist within a legal framework that includes legitimate regulations rooted in historical tradition. Responsible gun owners stay informed about legal requirements, comply with valid laws, and challenge unconstitutional restrictions through proper legal channels rather than through unilateral defiance that could lead to criminal prosecution. So, what comes next, and why is this Supreme Court order just the first move in what promises to be a much larger constitutional transformation? Supreme Court orders often signal bigger rulings ahead. When the court issues emergency relief or expedited decisions, it's frequently because the justices are concerned about constitutional violations that can't wait for the normal appellate process. But it's also often a preview of how the court will rule when full merits cases reach them on the same issues. This is a turning point, not an end point. The order represents a moment when the legal trajectory shifted, when constitutional standards were clarified, and when the balance between gun rights and gun control moved decisively in one direction. But it's not the final word. More cases are working through the courts, more legal challenges are being filed, and more opportunities for Supreme Court involvement are on the horizon. More decisions are coming that will continue to define the scope of Second Amendment rights, the limits of government regulatory authority, and the proper relationship between constitutional protections and public safety concerns. Gun owners, state officials, and everyone involved in Second Amendment litigation should prepare for an ongoing series of legal battles and Supreme Court interventions as the constitutional framework governing firearms continues to be rebuilt. Vigilance and constitutional awareness are essential right now because the rules are changing, the legal landscape is unstable, and the stakes for gun rights and gun policy have never been higher. This Supreme Court order that dropped minutes ago is not an isolated event. It's the latest move in a constitutional chess game that's been playing out for years, and the next moves are already being planned by advocates on both sides of the Second Amendment debate. What the Supreme Court just did will echo through American law and American life for years to come. And anyone who cares about gun rights, constitutional law, or the relationship between individual liberty and government power needs to understand that something fundamental just shifted, and the shift is only beginning.